Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to step out of our lane a little bit today. We're not going to talk about gun laws, but we are going to talk about constitutional principles as it relates to certain protected activity under the First Amendment. What are we talking about? We're talking about flag burning. That's right. Not that that would ever be an issue in modern day America, right? Well, as it turns out, yeah, it's a really big issue. It's got a lot of you really worked up, and I appreciate where you're all coming from. Who else it has really worked up is the current president of the United States, who has made multiple statements that he would like to see laws passed where people would be jailed for burning the American flag. I don't necessarily disagree with the principle, but the problem is that we do live under a constitutional republic, and we do have constitutional mandates and protections, and unfortunately, this activity is in fact protected by the Constitution. We'll explain how we got to that point. So today, let's spend a few minutes and let's talk about, like it or not, this is constitutionally protected activity. Okay, America, we're going to be talking about individuals who want to express their right of free speech by burning the American flag. Now, as a caveat, before we get too far into this video, I am not defending those who want to burn the American flag. I find it to be very repulsive activity. I do not agree in any way, shape, or form as that being a form of protest, but then again, that's only my opinion. I will also point out one thing, that while the First Amendment may protect your ability to say whatever you want, one of the things the First Amendment does not protect you from is the consequences of what it is you've chosen to say. And if you don't believe me, ask Colin Kaepernick. Now, a lot of people will tell you that the case of Texas v. Johnson actually said that burning the American flag was a constitutionally protected activity. That's actually not true. It was another case that came shortly after that called United States v. Eichman. What I'm going to do is I'm going to explain to you today the long journey that this country has been on to have the burning of the American flag as constitutionally protected First Amendment activity. Now, did a little geeking out about desecration of the flag as protected free speech because unfortunately that's the life I live. And it turns out that the first case to really ever kind of delve into this area was a case way back in 1907 called Halter v. Nebraska. Now, that case involved a beer company who wanted to sell their beer with the American flag on the label. Nice marketing. The state of Nebraska, however, felt that that was a desecration of the flag. They blocked them from doing so. And in trying to sue the state of Nebraska, the United States Supreme Court ultimately upheld Nebraska's ban on the beer label being able to use the American flag. Then in 1968, during all the turmoil surrounding the Vietnam War, as you know, the American flag was desecrated in many different ways as a form of protest. That led Congress to pass the Federal Flag Desecration Law, which actually made it illegal to knowingly mutilate, desecrate, destroy an American flag. That law remained into effect until the cases that we're now about to talk about. You see, the whittling away of that statutory protection of the flag first occurred out of a case from this state of Washington, in 1974 called Spence v. Washington. What Spence had done has used electrical tape to put the peace sign onto the American flag, had then been prosecuted for it, but the Supreme Court ultimately ruled that that alteration to the American flag was protected First Amendment activity. And so the erosion of that statutory scheme in 1968 began about 6 years later in 1974. Okay, then, but in 1984, along comes Gregory Johnson, who decides in a form of political protest that he's going to burn the American flag outside the Republican National Convention. He is arrested by Texas authorities, and he is ultimately prosecuted under Texas state law, similar to the federal law that prohibited the desecration of the American flag. He initially appealed, the conviction was upheld, but then by a higher Texas court, the conviction was overturned. It was then appealed to the United States Supreme Court in the now famous case of Texas v. Johnson, and in a 5-4 decision, the dismissal of the conviction was affirmed by the United States Supreme Court. Thus, they found the law to be unconstitutional. Justice William Brennan actually wrote the majority opinion and was joined on the majority by Justice Anthony Kennedy, Justice Thurgood Marshall, Justice Harry Blackmun, and Justice Antonin Scalia. The majority of the United States Supreme Court ruled Johnson was convicted for engaging in expressive conduct. The state's interest in preventing breaches of the peace does not support his conviction because Johnson's conduct did not threaten to disturb the peace. Nor does the state's interest in preserving the flag as a symbol of nationhood and national unity justify his criminal conviction for engaging in political expression. Justice Anthony Kennedy also authored a very well-written concurring opinion where he stated, "The hard fact is that sometimes we must make decisions we do not like. We make them because they are right in the sense that the law and the Constitution as we see them compel the result. And so great is our commitment to the process that, except in the rare case, we do not pause to express distaste for the result, perhaps for fear of undermining a valued principle that dictates the decision. This is one of those rare cases." Now, the Chief Justice, William Rehnquist, was part of the dissenting votes, as well as Justice John Paul Stevens, Justice Sandra Day O'Connor, and Justice Byron White. The Chief Justice authored the dissenting opinion which stated, "I cannot agree that the First Amendment invalidates the act of Congress and the laws of 48 of the 50 states which make criminal the public burning of the flag. The flag is simply not another idea or point of view competing for recognition in the marketplace of ideas." Congress then again passed the Flag Desecration Act of 1989 in an effort to, I guess, work their way around the Supreme Court's opinion, but that was challenged the very next year in the matter of United States versus Eichman, where once again a sharply divided 5-4 Supreme Court again struck down criminal prohibitions against desecrating and burning the flag as a form of free expression. The court there specifically stated, "If there is a bedrock principle underlying the First Amendment, it is that government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable." Now, that obviously did not end the debate, and as a matter of fact, in 2006, there was yet another effort to pass a similar piece of legislation, which failed by one vote in the Senate. Now, you guys may remember that Anthony Scalia was one of the justices who actually voted to strike this law down, and I think we all understand where Justice Scalia comes from on a political standpoint, but I think it also goes to show the intellectual honesty of Justice Scalia in the sense that obviously this was abhorrent acts in his mind. These were repugnant acts. And yet he still understood and upheld the constitutional principles of our founding fathers. And he was later quoted when asked about this case as saying, "If it were up to me, I would put in jail every sandal-wearing, scruffy-bearded weirdo who burns the American flag. But I am not the king." And so that America is why, as abhorrent, as repugnant as you may believe the activity to be, and I agree with all of that, it is still why that is a constitutionally protected form of free expression. And I want you all to remember what we started this video with, though, which is the premise that although the First Amendment may protect your ability to say whatever you want to say, the First Amendment does not protect you from the consequences of what you have chosen to say. Listen, we'll go ahead and link up some of the information down below so that if you want to geek out on it for yourself, you can do so. You don't have to take our word for it. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, America, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.